34. And it appears that you determined to spend a lot of time in custody. After this time, you need to sit at the jail, sit at the prison, and think about, why am I here? How did I get here? Do I really want to live my life? Institutionalized. Because if you do, what's going to end up happening is at some point, you're going to be labeled as a habitual offender. And in Texas, when you're a habitual offender, depending on the offense, your minimum starts at 25 years.
Keenan Brown was facing aggravated assault with a deadly weapon and robbery. He received a 5-year concurrent prison sentence, but Judge Boyd wasn't finished. At just 34, she delivered a warning about where this path could ultimately lead.
6:15. So it's 6:16.
All right. Court is calling 2022 CR 2790 and 2022 CR 10495, State of Texas versus Keenan Brown. Can I have the parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Arlene Gay for the defendant.
All right. And are you Mr. Brown? Counsel, have you received all the discovery in each case and did you review it with your client?
Yes, all the cases we're pleading on, except for one notation I was told today.
Judge, so on calls number 2022 CR 2790, there was a audio file that was mentioned in the prosecution guide from one of the witnesses. I had reached out to SAPD because we did not have that in our possession. SAPD reached out and said that they didn't have it. They updated me today, and that's when I told defense about it.
It's the conversation is noted.
Yes.
It's just the recording. If there was one ever made, it was not, and they told me, and that's one of the cases he's taken a plea on today.
All right. And knowing that, do you still wish to continue with the plea?
Yes, Your Honor.
And Mr. Brown, do you still wish to continue with the plea? I got it.
Yes, ma'am.
And are there any applications?
No, Your Honor.
And each cause number, I'm going to show you the court will find that the state is in compliance with discovering each cause number. And in each cause number, Mr. Brown, I'm going to show you what's entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State and the cause number ending in 10495. Are you proceeding on the indictment as presented?
Your Honor, I believe there's a repeat offender enhancement. We are not proceeding on that. We are waiving that. But otherwise, we're proceeding as presented.
Okay. Any objection?
No objection.
And in the cause number ending in 2790, state, are you proceeding on the indictment as presented?
Your Honor, the state is going to waive the repeat offender enhancement, but otherwise proceeding on the case as presented.
Any objection?
No objection.
Mr. Brown, in each cause number, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand them and did you sign them?
Yes, ma'am.
And the cause number ended in 2790, you're charged with the offense of aggravated assault with a deadly weapon. And the cause number ending in 10495, you're charged with the offense of robbery. Each of those offenses are second-degree felonies. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each of the cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering into these plea bargain agreements, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane in each of the cause numbers?
Yes, he is.
Mr. Brown, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial in each of the cause numbers. And each of the cause numbers, I'm showing you the plea bargain page. Did you review those with your attorney? Did you understand it?
Yes, ma'am.
In each of the cause numbers, punishment is to be assessed at 5 years in the prison. There are no applications. The cause numbers will run concurrently. The state will take into consideration 2022 CR 2791, 2023 CR 5662. This is to run concurrent with your federal case 22 CR 246. And did you understand that if the court finds that there was a deadly weapon in the aggravated assault with a deadly weapon, Then the court will enter an affirmative finding of deadly weapon. Did you understand that? Did you understand that to be your plea bargain agreements in each of the cause numbers? Defense, is that the plea?
Yes, it is, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
And each of the cause numbers, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, there hasn't.
Then in cause number 2022 CR 410495, how do you plead? Guilty, not guilty, or no contest?
No concept.
And in cause number 2022 CR 2790, how do you plead? Guilty, not guilty, or no contest? State any evidence to support the defendant's pleas.
State offers State's Exhibit 1 in both cases. It's different states' Exhibit 1s.
No objection.
All right. In each cause number, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, in each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, we're just asking that the court follow the plea bargain, and I'd like to address the documentation of back time in this matter.
Then in cause number 2022 CR 10459, the court is finding you guilty. Court will follow your agreement, sentence you to 5 years in the prison, give you credit for any time served. This will run concurrent with 2022 CR 2790. Take in consideration 2022 CR 2791 and 2023 CR 5662. This will run concurrent with federal cause number 22 CR 246. And counsel, you wanted to address the issue of back time?
Yes, Your Honor. I know there's probably some notes on your jacket that Mr. Brown was in federal custody. He was removed from Bexar County Jail in June of 2022. He was arrested. He was actually booked on 2/16/2022 here in Bexar County. He was here and then removed to federal custody and then returned from federal custody and has been incarcerated this entire time. I'm asking the court, knowing that that is what the court is aware of, that the court grants all time from 2/16/2022 to today, which is 1/16/2024, excuse me.
State
Yes, Your Honor.
on the back time issue?
Judge, my understanding is that he would be entitled to that under at least.
No. Have you done your research as well?
No, this is really the first we talked about it.
All right. You're an officer of the court, so you researched this and this is the time?
Yes, Your Honor, because was the delay in the case, was that he was in federal custody.
All right. So you say he's been in custody since 2/16.
2022 until today, 1/16/2024.
And Judge, I will say that does sound correct. Again, the specifics on the federal custody, I don't want to say, but that does sound correct.
All right. So he'll be given custody from February 16th, 2022 till today. Is there anything else with regards to that case?
No, Your Honor.
All right. And that cause number, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Next, we're going to proceed with sentencing in 2022 CR 2790. The court will follow your agreement, sentence you to 5 years in the prison, give you credit from credit for any time served beginning February 16th, 2022 through today.
Yes, Your Honor.
There's an affirmative finding of a deadly weapon. This will run concurrent with 2022 CR 10495. The federal case 22 CR 246, taking consideration 2022 CR 2791, 2023 CR 5662. Is there anything else with regards to sentencing in that case?
No, Your Honor.
And in that cause number as well, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. How old are you?
34.
All right, you're 34. And it appears that you determined to spend a lot of time in custody. After this time, you need to sit at the jail, sit at the prison, and think about, why am I here? How did I get here? Do I really want to live my life? Institutionalized. Because if you do, what's going to end up happening is at some point, you're going to be labeled as a habitual offender. And in Texas, when you're a habitual offender, depending on the offense, your minimum starts at 25 years. Do you understand?
Yes, ma'am.
So you're going to have to change your ways. And if you have an anger issue, you need to work on it. All right. Good luck to you.
Thank you.
You're welcome. Can I see the other files on here so I can write in the file? It's 5662 and 2791. And then we'll be back tomorrow at 9 and we'll start up a jury trial at 9:30. I don't. Thank you. All right. So everyone, this is what's going on with the jury trial. Some people didn't know that we were having court today. So there are a limited number of jurors who actually came for jury service. And so what has happened is jurors have been sent to misdemeanor courts. They've been run through and sent back downstairs. So we only have available for this court 60 jurors. And those are jurors who've already been questioned probably 2 to 3 times. As a former defense attorney, as a former prosecutor, I would always think that you perhaps would not want jurors who had already been questioned about 3 times. Now, if there is anyone who feels, no, I want those jurors who've been questioned 3 or 4 times. Speak now, forever hold your peace. I will consider it. Otherwise, what will end up happening is we will be back here at Wednesday. Jurors will know that there is court on Wednesday, so they will be here on Wednesday. We will have a juries up here at 9:30. You all will do jury selection, and after jury selection, I imagine we'll take a lunch break, and then at 1:30, testimony will begin. That's the court's proposal. Is there anyone who has an issue with that? All right. Everybody's silent, so I'm assuming no one has an issue with that. But for the fact that Ms. Ferguson was giving me notes saying that there's a limited number of jurors, we will be doing jury selection now. So for those of you all who are up for jury trial, if there's a motion or something you need heard or some discovery issues, now's the time to do that. Otherwise, I'm going to go through the docket and give you your reset for tomorrow. All right, so Rudolph Montoya. Can I see the file on Rudolph Montoya?
No, that's Mr. Gross.
All right.
Yes.
Yes. I'll come forward. So we're going to start jury selection tomorrow at 9:30. You were not here for this announcement, but your co-counsel was. Jurors didn't know that we were having court today. So there are not that many jurors. The 60 that are available for this court, they've already been questioned about 3 times. So we'll have more jurors. It'll be more than the 60. And we'll start jury selection tomorrow at 9:30. And we'll take a lunch break and then we'll start up with testimony. Okay. All right, Ms. Ferguson, we'll give you a reset form and we'll see you all then.
All right. There's things to take up. Would you like to do it in the morning, like at 9, or would you like to do it now?
Oh, let's do it now. What are we taking up? Do you have the motions?
I have, Your Honor, in there with your permission.
Yes.
This is in the 9179, the last 4-digit case. There's an advisory report to clarify presence of attorney.
I don't have that motion. Oh, thank you.
I am set for a large writ hearing in Live Oak County on Friday.
Okay.
I've had an agreed motion for continuance of that writ hearing. And the judge denied it. And I
Okay.
don't want to be put in a position of procedural default on that
All right.
case.
Well, let me ask you this. When is that hearing set?
It's set for 9 a.m. Friday.
All right. So then let's do this on this motion. Let's see where we are tomorrow. And then if something else is in trial and you're not in trial, then this will be a moot point.
Okay.
All right.
That's cool. I'll hang on to it for now.
Okay. Yes.
The other thing, Your Honor, we filed an election for punishment.
Mhm.
I'm sure that got filed okay this morning.
Yes.
We also filed a motion for community supervision. And I just wanted the record to be clear.
Oh, we're not on the record yet, but
Oh.
because I haven't called the case.
Okay.
But I can tell you is the election for punishment. The court has it. And if he were found guilty, it shows that he's going to the jury, correct?
Correct.
All right. So that's done and it's been file stamped. So it's in the file. The motion you had to transfer previous motions, and I'm assuming with that motion to transfer, it's transferring the court's previous rulings as well?
Right. Right. I spoke to the prosecutor about that.
Yes, Judge. Okay.
We're in agreement on that. The last thing, Your Honor, the indictment in this case, and this I think should be on the record. Just
I'm not going to put it on the record. I'm just trying to figure out what motions you have that you all are not in agreement with.
before Ms. Nelson became the first chair in his court, Brittany had the case.
Mhm.
And the old case had a single count for continuous with, I think, 3 offenses alleged under it.
Mhm.
The case got re-indicted. And it's artfully worded. Again, it's not on an accident, it was prior counsel. 4 counts got added, which are lesser included offenses. 3 of those 4 lesser included offenses of the continuous. And you'll see on counts 1 through 4 on the first page,
Yes.
they all allege 2015,
Well-
except the last one alleges 2016.
16, yes.
And you'll see the one that alleges 2016 on the bottom of the first page. I think it's April 2016, the bottom of the first page.
On the first page, count 4 is March 1st, 2016.
And then when
I'll do this to
No,
you.
no, it's fine,
You
Judge,
have-
I remember. And then
Okay.
on the second page, then, it begins September
Mhm.
2016. And I don't know why, but the state and I are in agreement that it's the same transaction.
Okay.
It's the same continuing transaction alleged, the same criminal transaction alleged, not agreeing it's criminal transaction, but it's because I don't know what happens if for some reason a jury convicts. I don't want there to be the appearance that waived anything under the Code of Criminal Procedure.
So what are
Section,
you all asking for?
say again.
What are you asking for?
I just want the record to be clear and all the parties agree that it's a proper joinder under Code of Criminal Procedure 21.24, so that I'm not waiving anything and subject to being stacked or something down the road, because
Okay.
we're in agreement that if there's a conviction on anything here, can only be 1 sentence, not a stacked sentence.
Oh,
So that's
okay.
what, just want to make that clear on the record, So I'm not waiving anything prior to the jury coming in.
No, and we'll put that on the record. So that's the only thing you want to say about the indictment? All right, so I'll let you place that on the record, but the court understands that. All right, we'll go on the record in 2023 CR 9179, State of Texas versus Rudolph Montoya III. Could I have parties announced?
Anna Ochoa Nelson for the state.
Afternoon, Your Honor. Michael Gross for Rudolph Montoya were present.
And you're Mr. Montoya?
Yes, Judge.
All right. So off the record, there are some issues that have been clarified. Number one, if Mr. Montoya were found guilty, he would be going to the jury for punishment. Is that correct, counsel? Is that correct?
That's correct, Your
All
Honor.
right. Number two, defense counsel filed a motion in cause number 2023 CR 9179 to transfer the motions and the on those motions from 2019 CR 9952 and the instant case ending in 9179. Is that correct?
That's correct.
Your Honor, with regard to that, that would include notices as well.
Defense?
Exactly. We that, and thanks for bringing that up. So in other words, I filed some business record affidavits with prior counsel under the old case for the CPS file and the hospital file. And prosecution provided us with 404B notice and a list of witnesses, including experts under the old cause number. And we were in agreement that the transfer, no problem, over into the current case.
All right. And then the other thing, defense counsel has filed a motion for community supervision, application for community supervision in this cause number. That's correct, counsel?
That's correct, Your Honor. Obviously, we're not eligible for any of the counts charged in the indictment. It's just in case something comes up unexpected. We don't want to be caught flat-footed that we didn't file much for probation should something come up.
All right. And then the other issue that we discussed off the record and the court discussed it off the record for clarification is in regards to the indictment in the cause number ending in 9179. And defense, you wanted to put something on the record with regards to that?
Yes, Your Honor. Under the old cause number, there was only one, and that was the continuous sexual abuse count. And it had a broader range of time on the original indictment in the former case. In this new case, 2023 CR 9179, counts 1 through 4, counts 1 through 3 deal only with 2015, and count 4 deals with March 2016. And then for some reason, count 5 does not include the range of the range of offense counts 1 through 4. Count 5 starts with September 2016. And so we didn't want to be put under a position of waiver under Article 21.24 of the Code of Criminal Procedure that these are improperly joined. The state and I had discussed it and we're in agreement that these are all the alleged same criminal transaction, not anything that would raise the level of being stackable should there be any convictions.
And for clarification, Your Honor, I believe it's count 2 that is a breast touching. Of course, that can't be included in a continuous sexual abuse of child case. So that would be outside of that continuous indictment.
Okay. All right. Is there anything else, counsel?
No, Your
All right. So what the plan is, we'll be back here tomorrow at 9:30. And Mr. Gross, the court is aware of your issues on Friday. Okay.
because we off the record, like we're in about a week and a half trial roughly.
All right. Yep. You said about a week and a half, probably 3 days.
I think we were 3 days last time, Judge. Of course, we've got some copies of testimony now. I think it might stretch it a little bit more, but I don't think it'll be too terribly out of control.
Okay. All right. So just sign the reset form, then you're excused, and I'll see you all here tomorrow at 9:30.
Thank you, Judge.
All right. And I'm expecting the jurors to be lined up in the hallway at 9:30, so no interactions. I know you all would not, but I just have to say that.
I might high five a few.
Okay. David Duenas. All right. You all will come back tomorrow. So it'll be tomorrow at 9:30. Is there anything else that needs to be taken up?
Nothing from the state. I don't think so.
All right. And counsel, if your client were found guilty, have you decided on punishment?
No, I did discuss that with him before lunch, Judge, and I was gonna touch base with the state and see if we're on the same page about what he's eligible for probation on from the
Okay.
jury versus the court, and then we'll decide.
All right, so make sure that's done before 9:30 tomorrow.
Understood.
All right, Ms. Ferguson, we'll give you a reset form, then you're excused.
Judge, may I ask you a quick clarification? Am I third in your lineup?
Oh, I don't do numbers in lineups.
Okay.
It just will,
I-
it's all, Norma will tell you,
Okay.
when she was the advocate for me and we had a jury trial, and she would say, what's going to happen? I'm like, fluid. So this is all fluid. And she said, what does that even mean? So she would ask my friends, what does that even mean? So we worked together. I think after the 3-month mark, Norma was like, oh, I know what that means now. So you have to talk to her about the nuances of it's all fluid.
There's a possibility I don't go.
There's a possibility that we may have a freeze
Okay.
and the world comes to an end, but I just don't know.
Thank you.
I hope that answers your question.
I won't high five all the jurors.
Okay. Alex Espinoza. Hi.
Morning, Judge.
Good morning. Where's Espinoza? Hello.
Good morning, Judge.
Good morning.
Or afternoon. Afternoon.
Oh, yeah.
It's morning somewhere.
Yes. Discovery.
Yes, Judge. I have communicated with the state what we're still missing.
Okay, what are you missing?
The incident detail report. There's a phone conversation with our client.
Okay, just 1 second.
Yes, Judge.
State incident detail report.
Judge, I tried checking right now. I didn't see it. I can probably get that relatively quickly.
All right, what else?
It's a phone conversation with our client between him and I believe it's the detective, but someone from the law enforcement agency. I believe there should be a recording of that.
And my understanding, Judge, is that from reading the report, it was captured on a body cam. I have to go through and look through the body cam to see if we actually have
All
it.
right, so have you turned over body cam?
My understanding, yes, from looking at the list, I just haven't been able to go in and see whether or not the body cam that we have already turned over, that's gonna answer or have it on there.
All right.
I haven't seen it on the body cam, but I will tell him my efforts in the
Okay.
body cams to.
All right, what else?
And there was a third, it is confirmation. This started off as a DWI and we have no DWI report. And so we're looking for that report.
Judge, I didn't see any, but I can request the officer, talk to them, see what happened with that.
Anything else?
That's it, Judge. With the caveat that the IDR is an indicator of everyone who's on the scene. And often when I get that, I realize that we might be missing more, but because it lists all the officers.
Right. Then you all need to do that off docket.
Yes, Judge.
So I'm going to give you all the final reset on this for discovery. Ms. Ferguson?
Yes.
Can I have a date in 35 days?
I can do February 1st. No, I'm sorry.
It's all fluid.
I can do February 22nd.
All right, February 22nd. All right, once you sign the reset form, you are excused.
Thank you, Judge.
You're welcome. Jerry Torres. All right, discovery issues?
We have everything that the state has said that they've given us. So everything that we think we need, we have.
All right, is there a blood draw on this?
My understanding, Judge, is that it was a blood draw.
All right, do you have blood discovery?
We don't.
All right, so they don't have blood discovery, but they say they don't need it.
That's not what we're saying.
Okay, so
I don't know if a motion's been filed on that, Judge.
has a motion been filed?
Request has been filed, Your Honor.
All right, could you pull that blood discovery order? Other than blood discovery, anything else, any videos,
Nothing that I'm aware of.
any incident detail reports?
Not that I'm aware of, Judge.
Oh, I'm sorry, it's 2023-8909. And this will be coming back on the 22nd as well.
Thank you, Judge.
Sure.
You
But
think
this
there's
one,
blood discovery?
yeah, the order that was filed by defense.
She has to talk. You think it's in the file?
No, it's not in the file. But if you all want to double check the file,
No, it's okay. Give me 1 second.
Deputy Laura, if it is in that file, this is going to be
It's not.
an
on 360.
episode from Fool Me Once.
Judge, it's not on 360. The only thing I have in there is just the.
All right, so we don't have your order.
I'm checking the date for the e-file, Judge. May I be excused to use my, I'm having difficulty on my phone. looking for
Sure.
it. May I be excused to look at that on the, my computer, Your Honor?
Yes.
And then confer.
All right,
with
thank
the
you.
state and with the court.
Okay.
Thank you, Judge.
You're welcome. So you're going to take care of that today, though, because I need to know about it today.
I'm not leaving until we address that issue.
All right, thank you.
Thank you, Judge.
Darren Does.
Keenan Brown walked out of this hearing with a 5-year concurrent sentence and significant credit for the time he had already spent in custody. But Judge Boyd made it clear that the sentence itself was only part of the message. At 34 years old, Brown was being warned to seriously reconsider the choices that had brought him back into custody. The judge cautioned that continuing down the same path could eventually lead to habitual offender consequences, and far more, serious prison exposure. Whether that warning becomes a turning point is ultimately up to him. This hearing also shows how plea agreements, concurrent sentences, deadly weapon findings, and prior criminal history can shape the outcome of a criminal case. If you want to see whether defendants take a judge's final warning seriously or return to court facing even greater consequences, subscribe and follow this channel for more real courtroom proceedings and the decisions that can change a defendant's future.